What happens if you don't have an estate plan? Hi, I'm Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and today I would like to answer that question for you because it was recently asked of me. Well, whether you have a written estate plan or not, you have an estate plan. So typically the documents that we see in an estate plan can be a will or a trust, or a will and a trust, a power of attorney, and a healthcare power of attorney. So typically, if you're still alive, the power of attorney and healthcare power of attorney come into play. So if you lose your mind and you don't have a power of attorney in your estate plan, then you're going to have to go ahead, and your family's going to have to go ahead to court and get a guardian appointed to make your business decisions, potentially handle your financial issues, and make your healthcare decisions. On the other hand, if you do have a power of attorney and a healthcare directive, all that information will be in stone, and your power of attorney and healthcare proxy or healthcare representative will be able to make the decisions if you cannot physically make those decisions because of a physical problem, or you lose your mind, or you are just not mentally competent, whether it's a permanent incompetency or just a temporary incompetency because you are hospitalized. So during life, you have the power of attorney and the healthcare power of attorney. Now at death, if you don't have any type of estate planning document, then the state information comes over, and we're bound by the intestacy statute. And what the intestacy statute says is, okay, we are going to put rules around the assets and distribution of the decedent's estate. And the way that we do that is we look at the familial relationship. So, if you have a spouse and all your kids are from the relationship with your surviving spouse, then the statute will say that the stuff gets dispersed a certain way. If you have a surviving spouse that might be a second or third spouse, and you had kids from another relationship and no kids from your final relationship, then the distribution is going to go another way. If you have no surviving spouse and you have kids, then the distribution is going to go another way. If you do not have a surviving spouse and you do not have kids, then the law requires you to look at siblings and parents. And so then it goes down the line based on familial relationship. The problem is there might be some people in your family that you want to get your stuff, and others that you don't want to get your stuff. And if you don't put together a plan, then it's going to be equally distributed regardless of the relationship that you had with those family members. If you have any questions about what an estate plan is, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.